Good afternoon, everyone, and thank you for taking the time to be with us today to talk about OSHA's newest ETS, that pertaining to mandatory vaccination and testing for large employers. I am presenting today with my colleagues Mike Neary and Nicole Behrman, and we have divvied up the content so you get to hear a little bit from each of us, and then of course we will finish up with questions. So feel free to use that chat function in Zoom, and we will take your questions at the end. Also, just to let you know, we are recording this during the presentation part, but we do intend to stop the recording for the Q&A, just so people feel comfortable participating in that if they want to do it using the chat function or even unmuting and asking a question. So with that, I will get started. As we all know, last week, OSHA, in the immortal words of Pat Benatar, hit us with its best shot, right? And issued that ETS that we've all been waiting for pertaining to mandatory vaccinations and testing for COVID-19 for large employers. The ETS says that all large employers must mandate that their workers either be fully vaccinated against COVID-19 or must submit to that weekly testing, where they will face penalties up to $14,000 per violation. And the basis for that, right, and what they so eloquently set forth in the 90 pages or so that in the preamble to the regulations, they explained that the basis for this is that they have determined employees are being subjected to grave danger from exposures to substances and agents determined to be physically harmful, specifically COVID-19 in the workplace. They note the severe health consequences associated with exposure to the virus, along with the evidence demonstrating that the virus has been transmitting in workplaces and the prevalence of infections among employee populations is the basis for this. And they note in talking about why they picked, 100 employees as that threshold number, that larger workplaces are more likely to have larger groupings of people and therefore increased likelihood of transmission. OSHA believes that because vaccination can largely prevent death and severe illness associated with COVID-19, that is the reason for this emergency temporary standard. And they also set forth that for those who remain unvaccinated, further protection can be provided through regular testing and use of face coverings and removal of all infected employees from the workplace. So those aspects are included in the ETS as well. As I mentioned, this is an emergency temporary standard. So that means it's only in place for 6 months until May, and then it must be replaced with a permanent standard. That permanent standard will undergo the formal rulemaking process that we all know and love from other regulations in the past. And so right now they are in that process of gathering information and comments and questions from the general public as they move forward in that rulemaking process. Notably, a final rule on this ETS does not require the finding of grave danger, which was the finding that was allowed them to issue the ETS. Instead, for a final rule, there is a lower standard of significant risk from exposure to COVID-19. So a little bit less high of a threshold to reach in order to implement the final rule starting in May. Also, as you all know, over the weekend, that Federal Court of Appeals for the Fifth Circuit issued an order temporarily suspending implementation of the ETS. And I'm sure you all have seen many of the other cases that have been filed in courts around the country challenging the mandate. There are also many states who have taken it upon themselves to issue laws both in an attempt to some degree expanding the requirements of ETS, and in other situations attempting to block aspects of the ETS. So of course, that makes all of this extremely confusing. So our goal today is to go through the requirements of the ETS. We're going to look first at coverage, both as to employers and also as to employees. Then we'll look at what the ETS requires of employers in terms of documentation, reporting requirements, the leave that must be provided associated with vaccination, masking requirements, the testing protocols, if that is what the employer chooses to do, accommodations that must be provided under this program. And then finally, we're going to talk about the impact of those state and local laws and that litigation attempting to block the law. And we're hoping to help you devise a strategy for how to deal with all of the unknowns that currently exist with regard to implementation of the ETS. So continuing with my Pat Benatar theme, let's get down to it. So I'll start first by talking about the coverage aspects of the ETS. So if you, Scott, could go forward to the next slide. Which employers are covered by the ETS? As you all know, there is a 100 employee threshold for coverage under the ETS. Again, the reason for that, as I said, is that OSHA believes employers with 100 or more employees have the capacity to implement this standard. They have the administration and kind of main office capabilities to implement a requirement such as this without significant difficulty. They also believe that by focusing on employers with 100 or more employees, they will reach 2/3 of all private sector workers in the nation, including those, as I mentioned, that are working at the largest facilities where they note there have been, in some instances, deadly outbreaks of COVID-19. OSHA has indicated that they do plan to analyze whether there could be application of a mandate such as this to smaller employers in the future. And as part of the rulemaking process, they are asking for feedback from employers and stakeholders with regard to that. So digging in a bit more as to what that 100 employee threshold means. So I know I've received a number of questions about that. So they do, OSHA did give some details as to how the 100 employees calculation should be done. So initially, employers should be looking at the number of employees they currently have now at any location across the US. But they note that employers should also be aware that if they currently don't have 100 employees, but they do hit that 100 employee threshold during any point when the ETS is in effect, that they will then become covered. So that means if you currently have 96 employees and you are planning to hire 4 more between now and May, as soon as you bring on those 4 employees, you will be covered by the ETS. The other interesting thing is that they said that employers whose employee count actually goes down below the 100 employee threshold will remain covered during the ETS. So you have those 100 employees and for whatever reason you lose a handful or even one, quite frankly, you will remain covered even though you're no longer at that 100 employee threshold during this ETS covered period. And the reason for that, they essentially said, well, look, if you've already gone to the trouble of having the administrative aspects of this covered, you've done the work, so to speak, no point in unraveling that just because you haven't hit, that you no longer have the 100 employees. As I mentioned, it's not a per location requirement, right? They can be 100 employees throughout any location in the US. Regardless of where the person works, including people that are working from home, working from the car, working outside. That all, as we'll talk about in a minute, has to do with whether the employee themselves is covered. But in terms of counting the number of employees, those workers are all included. As are part-time, temporary, and seasonal workers. All of those workers are included in the 100 employee count. The only workers that are explicitly excluded are independent contractors, according to OSHA. The other question that has come up with some regularity in the past week has been for companies or employers that have multiple entities that are related. And oftentimes there could be a situation where there are different EIN numbers, different payrolls, but the entity is related, or multiple entities are related in some way. And so OSHA doesn't speak directly to that point, other than to say that there is a concept of single employer for purposes of the Act, where two or more related entities could be regarded as a single employer if they handle safety matters as one company, right? So if their safety practices are done by a control and in leadership, and that leadership is consistent throughout the various entities, then we believe it's likely that all of the employees of those entities would be placed together for purposes of determining whether the employer meets the 100 employee threshold for coverage.
Julie, if I can throw in a question here, because it's directly relevant to this. Somebody asked, what if we normally have 105, but due to open positions currently are only 95? Can we wait until we get 100 again?
Yes. So if you currently, at the time that the ETS went into effect, are under 100, then you're not meeting, you haven't met the threshold. And once you hit that 100, then that's when it goes into effect for you. So it applies going up. If you are at 100 and you lose employees, it still applies to you. If you're using a staffing agency, however, those employees do not get included in your employee count for purposes of meeting the threshold 100. The other thing that OSHA speaks to in the guidance and the FAQs has to do with a multi-employer work site. And they use the example of a construction site where there are multiple employers all working on the same location at the same workplace for different entities. And here, unlike that single employer concept, each of those entities would be handling their own safety issues independently of one another. Then in that situation, OSHA makes clear that you only count your own employees. There's no combining with other companies, other contractors, let's say, that are on that construction job site. Although, remember, it's not exclusively those employees that are on that job site. You would still continue to look at all of your employees on all of the various job sites you have active at the time. The other thing to be aware of are some important exclusions to coverage. So somewhat thoughtfully, I think, the ETS excludes workplaces that are subject to the Safer Federal Workforce Task Force, which mandates vaccinations of workers working on or in connection with a federal government contract. That was the executive order that came out recently. And then at the end of September, we got that additional guidance for. So if you have workers who are subject to that executive order, they are not also subject to the ETS. They're only, you only have to apply the guidance from the Safer Federal Workforce Task Force. If you have employees that are, where you were able to segregate them, or you only have a portion of your workforce that is working on or in connection with a government contract, and you have others that are, let's say, only, working for private customers or private clients, then you would have compliance obligations under the ETS for those that are not working on the government contract side. And then you would have to comply with the government contract rules with regard to those working on or in connection with the federal contract. Also, another exclusion is for workplaces where any employee is providing healthcare services or support services that are subject to the requirements of the recently issued healthcare ETS. So several months ago, OSHA had previously issued a separate determination that grave danger existed for some healthcare and healthcare support workers, and it issued an ETS pertaining to that. And so while that separate healthcare ETS is in effect, workers subject to that are not subject to the large employer vaccine mandate that OSHA just issued last week. What about state and local governments? The ETS does not apply to workers of state and local government employers in states that do not have state plans because that's explicitly one of the exemptions from OSHA coverage. However, as you might have heard, there are certain states, I think there's 26 of them, in which they have their own state approved plans for OSHA. And so they now have 30 days in which to issue their own version of this ETS that provides at least as much protection as the federal one issued last week does. So it is quite possible that those state plans will include employees of state and local governments. So for any of you thinking about that, stay tuned for issuance of those state approved plans coming forward. Scott, can you go to the next slide? So the next thing I want to talk about has to do with the employees themselves who are exempt from coverage of the ETS. So there are some workers who are not subject to the vaccine or testing mandate. Specifically, workers who do not report to a workplace where other individuals are present, right? Perhaps they have an office where they go themselves and there's no one else there. They are excluded from coverage. Similarly, anyone who works exclusively from home and teleworks exclusively from home, they are not subject to the requirements of the ETS. However, if they are working a hybrid arrangement, right, where they are working part of the week, let's say from home and part of the week from the office, they would be included. And then the other exception has to do with workers who perform their work exclusively outdoors. And so why is OSHA exempting these three types of workplaces? Going back to the reason for the rule, right? These workers, they believe, do not face the same grave danger from occupational exposure to COVID-19 because of the nature of where they're performing their work. I want to talk just a little bit briefly in terms of what that exclusively outdoors concept means, because OSHA is applying it quite narrowly. In the preamble to the regulations, they note that oftentimes workplaces are characterized as outdoors, but they actually involve significant time spent indoors. And so they use, again, for an example, a construction site where workers are inside, part of the time. Maybe they're in a construction trailer where other individuals are present. Maybe they're sharing work vehicles associated with performing work outdoors. All of those indoor exposures, they believe, could result in spread of COVID-19 amongst employees, and so therefore would disqualify them for being outdoor work, meaning that they would be included in coverage of the ETS. Essentially, unless it's a de minimis use of indoor space and they use, for example, a bathroom or an administrative office that they're only in for a very short amount of time, a very brief amount of time, then they are going to be covered in terms of the ETS. And notably, they looked at various types of work and have a chart in the preamble for those of you that are interested. And they found really it's only landscaping and groundskeeping workers in a general sense that are working 90% of their time constantly outdoors, and all of the other types of work, they said really wouldn't meet that threshold of being exclusively outdoors. So bottom line, to meet that concept of being outdoors, the employee has to be outdoors on all days. So an employee who works indoors some days, outdoors on others, would still be required to comply with ETS. They can't routinely occupy vehicles with other employees as part of their work duties. So any of that driving together to a work site or public transportation, or private transportation that you're using to get employees to a work site would all subject them to coverage under the ETS. And then finally, if the employee works outdoors for the duration of every day, except for that de minimis use of indoor space, again, the multi-stall bathroom or the administrative office, then they could be exempt from coverage. Okay, and with that, and I'm going to move forward and introduce my colleague, Nicole Behrman, who's going to talk more about the requirements of the ETS. So I'll turn it over to Nicole.
Thank you, Julie. So as Julie mentioned, we're going to turn to the requirements of the OSHA ETS. And first, under the ETS, employers are required to draft and implement a written policy that requires employees to either be vaccinated or submit to testing. Employers are also required to notify employees of the requirements of the ETS and the written policy they implement. The ETS's prohibition on discharging, discriminating, or retaliating against an employee for reporting any work-related illnesses or a violation of the ETS, and the criminal penalties associated with knowingly supplying false statements or documents, which is not more than 6 months. Employers are also required to provide employees with one of a CDC published document that's called Key Things to Know About COVID-19 Vaccines, which discusses vaccine efficacy, safety, and the benefits of being vaccinated. Scott, can we turn to the next slide, please? Thank you. So moving forward with more requirements, to comply with the ETS, employers must determine the vaccination status of all of their employees. And for employees that are partially or fully vaccinated, employers must also require these employees to provide acceptable proof of vaccination status. The ETS also defines what acceptable is. And under the ETS, acceptable proof of vaccination is a record of immunization from a healthcare provider or pharmacy, a copy of a COVID-19 vaccination record card, a copy of medical records documenting the vaccination, a copy of immunization records from a public health, state, or tribal immunization information system, or a copy of any other official documentation that would contain what the vaccine has, the dates of administration, and the names of the healthcare professionals that administer the vaccine. Now, importantly, employers cannot only ask employees to show proof of a vaccination. Under the ETS, employers are required to retain a physical or a digital copy of the employee's proof of vaccination. Now, the ETS does have one exception to the acceptable proof of vaccination requirement. If an employee is somehow unable to produce acceptable proof of vaccination, the employee can sign and date a statement that attests to their vaccination status, attests that they have lost or otherwise are unable to produce proof of vaccination, and they have to declare that the statement about the vaccination status they are making is true and accurate, and that they understand that knowingly providing false information regarding their vaccination status will subject them to criminal penalties. In addition to the proof of vaccination requirement, employers also have to maintain a record of each employee's vaccination status, preserve the proof of vaccination that they do receive, and maintain a roster that includes all their employees and their vaccination statuses. Now, importantly, the record, the proof of vaccination, and the roster are considered medical information, and they must be kept confidential. The ETS also makes clear that employers only have to keep records and maintain a roster and obtain proof of vaccination for employees for their primary vaccine dose or doses. So either their first and only dose of the Johnson & Johnson vaccine or the 2 doses of their Moderna or Pfizer vaccines. So this means employers don't need to obtain information or keep records on their employees' receipt of booster vaccines. And if an employer knows that any proof submitted by an employee is fraudulent and accepts that proof as a record of compliance, the employer can also be subject to penalties. Next slide, please. And the ETS also has requirements regarding providing leave to employees to obtain a COVID-19 vaccine and to also recover from side effects of the vaccine. So first, under the ETS, employers must provide a reasonable amount of time to each employee to receive their primary COVID-19 vaccine dose during work hours, including up to 4 hours of paid time at the employee's regular rate of pay for each dose of the primary vaccine. Employers can't require employees to use personal time or sick leave to get vaccinated. But if an employee chooses to receive a primary vaccine on their own time outside of work hours, employers are not required to provide them paid time for the time they spent getting vaccinated. And if an employee needs more than 4 hours, and that's reasonable under the circumstances, the employee's leave would be unpaid. Now, while employers have to provide paid leave to get vaccinated, employers do not need to reimburse employees for transportation costs like gas, metro fare, incurred in obtaining the COVID-19 vaccine under the ETS. And the ETS also requires employers to provide reasonable time and paid sick leave to employees to recover from side effects of the COVID-19 vaccine. And if an employee has accrued paid sick leave, an employer can require the employee to use that paid sick leave to recover from side effects. Employers, though, cannot require employees to use other types of leave, like vacation leave. Employers can also not require employees to use advanced sick leave or incur a negative leave balance to take leave to recover from vaccine side effects. And if the employee has no accrued sick leave, the employer has to provide reasonable paid time off for the employee to recover. Now, I think this leads to the question, well, what is reasonable paid time off? And the ETS actually doesn't define what reasonable paid time off is, but OSHA issued an FAQ, and the OSHA FAQ states that employers can set a cap on the time that they must provide to employees to recover from side effects of the COVID-19 vaccine. And generally, if an employer makes up to 2 days available for an employee to take paid leave, this would comply with the ETS. So while these are the requirements of the ETS, there are some state and local laws that require employers to provide more leave than required by the ETS, and leave to care for children that receive vaccination, or also laws that apply to smaller employers that might not meet that 100+ threshold of the ETS. So you should check your state and local law where you have employees to see how the ETS interacts with state and local law and determine whether there are additional leave obligations that you have under state law. Scott, can we go to the next slide, please? So masking. Under the ETS, employees who are not fully vaccinated must wear face coverings when indoors and when occupying a vehicle with another person for work purposes. There are limited exceptions to the masking requirement. Employees do not have to wear face coverings when an employee is alone in a room with floor to ceiling walls and a closed door. So they would have to wear one at a cubicle. For a limited time while an employee is eating or drinking at the workplace, if they need to be identified for compliance with any safety or security requirements, if an employee is wearing a face mask or respirator, and under the ETS, a face mask is defined as a surgical mask. And then also when an employer can show that the use of a face covering is either infeasible or creates a greater hazard. Not only do vaccinated employees have to wear a face covering, but employers must also ensure that the face coverings fully cover their nose and mouths and are replaced when they're wet, soiled, or damaged. Now, under the ETS, employers do not have to pay for the cost of face coverings, but you may be required to other state laws or regulations or CBAs. And while the ETS only requires unvaccinated employees to wear masks, there might be state-specific orders or laws that require fully vaccinated employees to wear masks in areas of substantial or high transmission. And Scott, go to the next slide, please. Another requirement of the ETS are reporting requirements. And under the ETS, employers must report to OSHA each work-related COVID-19 fatality within 8 hours of learning of the fatality, and each work-related COVID-19 inpatient hospitalization within 24 hours of learning about it. And an inpatient hospitalization is defined as a formal admission to the inpatient service of a hospital or a clinic or any type of care for treatment. And with that, I will turn it back to Julie to discuss testing under the ETS.
Thanks, Nicole. So what about the employee that doesn't want to get vaccinated, who does have to report to a workplace with other employees present? The ETS provides that they must submit to weekly testing under a weekly testing protocol that requires them to both take and provide proof of a negative test at least once every 7 days. If an employee, however, goes to the office or that workplace with other people less often than every 7 days, then that employee only needs to be tested within 7 days prior to the date they return to the workplace and must provide that test result, that negative test proof upon their return to the workplace. So if you have someone that's on a permanent hybrid schedule where they're working less time in the office, and if that is, they're out greater than 7 days, they simply need to provide proof of the negative test within the 7 days of the date on which they return back for their regular time back in the office. Thankfully, OSHA provided details on the type of tests that are acceptable. So specifically, they've said that any test that is cleared, approved, or authorized, and that includes an emergency use authorization or EUA by the FDA, is acceptable. As long as it is administered in accordance with the authorized instructions for that test, and it is not both being administered and read by the employees, unless it's being observed by the employer or another authorized telehealth proctor. So as long as the employee is only doing one of the two, right? If the employee is swabbing themselves and then it's being submitted to an entity to do the results, that is fine, because there's only, the employee is only doing one aspect of it. So any lab process test is going to be okay. Over-the-counter tests are also going to be okay, where the collection and processing is either done or observed by an employer. That the antigen test is okay, as is the NAT, or the nucleic acid amplification test. However, antibody tests are not okay, right? Because antibody tests aren't telling us whether or not the worker has an active case of COVID. Interestingly, pool testing, which is that concept of combining specimens for multiple workers and conducting one antigen test for the entire pool, is also permissible. The benefit, of course, of pooling your tests is that it will lower your overall costs. The downside, of course, is if you have a positive result, it will require you to retest everyone who had a specimen in that pool. And that might, have to require an additional swabbing as well. Of course, if there is a positive test, the employer is required to remove that worker immediately from the workplace. And in order to return to the workplace, the employee must receive a negative result on that NAT test or meet the return to work criteria established by the CDC in their isolation guidance, or receive that recommendation to return to work from a licensed healthcare provider. There's no requirement to provide paid leave during that removal period under the ETS. But as Nicole mentioned, always really important to keep in mind any state or local paid sick leave laws that might be applicable. Also, during that 90-day period following a positive test result, there's no testing required. And the reason for that is simply practicalities. The worker is likely to result in a positive test. And so they said after somebody has COVID, 90 days, no testing required. Employers have to maintain all testing records while the ETS is in effect. And as with vaccination records, that documentation is not subject to the 30-year rule that's otherwise required under OSHA, but it is still considered a confidential medical record that must be maintained separately from the employee's personnel file and only disclosed on that need-to-know basis. Another interesting nuance that I think helps a bit in terms of flexibility, which we're all looking for here with regard to application of the ETS, is that OSHA says in its FAQ that employees who have completed their entire primary vaccination series by the deadline, which is currently in January, if they have, that means if they've had their first shot and first and only shot of the J&J, and they've had both of their Pfizer shots or both of their Moderna shots, you do not have to test those folks in the 2-week waiting period following the final shot. Also important to know that the ETS is not requiring employers to pay for any costs associated with the testing. However, there could be other state and local laws, or maybe even some federal laws that could require that employers pay for that. In addition, it is likely to be a subject of collective bargaining. If you have a organized workplace in terms of, and have union reps, of course, you're going to have to bargain over implementation of these rules, and payment for testing could be something that is comes up as part of those negotiations. Of course, OSHA makes clear an employer is not prohibited from paying for any costs associated with testing, and they leave it completely up to the employer. OSHA expects that there are going to be some employers that are going to think that they need to do this in order to induce their workers to stay, given the tight labor market. But they also note that there could be some employers that simply want to shift the cost over to the worker that's choosing not to be vaccinated, right? And simply saying it's up to you to cover this. It's your choice if you don't want to be vaccinated. Important to remember that previously the Department of Labor did issue some guidance in their FAQ with regard to whether testing time is compensable time. And they said that during a regularly scheduled shift, if you send somebody to be tested, that is going to be compensable time. So we certainly need some clarification from the federal government on how all of these laws interact. And we do expect more guidance to be forthcoming as we move through this process. So now I will turn it over to my colleague, Mike Neary, who's going to talk about accommodations and the impact of all the laws and litigation.
Thanks, Julie. It's been a whirlwind since the Biden administration announced the plan for this OSHA ETS to come out. And it's been a heck of a week for us here trying to get our heads around what it all means. And I'm sure everybody out there is, their heads are spinning as well, because there's a lot to digest here and a short amount of time to process it all. So thank you all for hanging in there and doing your best to comply. I'm going to kind of briefly walk through some accommodation principles that still apply to the mandates of the ETS, and then get into the messy conflict between certain states and the federal government over this and what it all means for you. I kind of have been thinking that employers are, the children in a bad divorce trying to figure out what to do in this circumstance. And so hopefully I'll give you some words of wisdom about how to process what's really going on in the country, where, half of the states are putting up roadblocks to this mandate. So focusing first on this accommodation issue, the ETS acknowledges, the federal law, the federal requirements to reasonably accommodate for individuals, employees with religious beliefs and medical conditions that may compel them to request an exemption to the mandates of the ETS. They still apply. These principles are ingrained in the law under the Americans with Disabilities Act and under Title VII and the Civil Rights Act. And so, for employers that are going to elect to comply with the ETS by allowing employees to decide whether to get vaccinated or to test weekly, you might not have a lot of accommodation issues arise, because the primary thing that we're seeing where employees are asking for accommodations from all of this, center upon, vaccination requirements. But nevertheless, you may get some, even if you have a testing opt-out process effectively. You might get individuals who say they can't test because of a medical condition or a religious, objection to it. And, you want to have protocols in place to handle those and evaluate those as they come up. And, but if you're going to go down the road of requiring the vaccine as part of, your compliance effort for this ETS, you should anticipate and prepare for an influx of requests for accommodations. In the OSHA ETS, I think they predicted 5% of employees will request an accommodation from a vaccine requirement. But depending on the industry you're in or the location your business has employees in, that number could be significantly higher. So having sound processes in place for allowing for accommodation requests to be made should be kind of a priority as you figure out a compliance plan. So you want to have, a group of individuals to evaluate requests that come through. You want to advise your managers that while your policies are going to be requesting accommodations to come through in writing, that if managers are on notice of individuals, employees who have medical conditions or who have religious objections to these mandates and protocols in the ETS, they can't just stick their head in the sand. They need to be prepared to interact with those employees and provide them with the proper documentation and request that they submit them in writing so that you can evaluate the request. And what the ETS makes clear is that masking and testing requirements for the unvaccinated apply for employees who qualify for accommodation. So if somebody comes forth and says, I want an accommodation for the vaccine mandate, one of your reasonable accommodation protocol will have to have the masking and testing requirement. And the ETS recommends that employers consider the most protective accommodation, such as telework. So if the position is telework possible, what they're basically saying is employers should strongly consider having telework be the accommodation provided to an individual who won't get the vaccine because of a medical issue or a religious accommodation. When it's not viable, you want to come up with your accommodation plan, which would require the masking and testing. Now, you could have unusual circumstances where individuals request accommodations for masking and testing because of medical reasons or religious beliefs. And don't roll your eyes or scoff at them, evaluate them individually, engage in an interactive process with them. If you need additional information from a medical professional, there's a process to follow to get that information. If you need more information from the individual to evaluate the sincerity of their religious belief, you want to be cautious in how you approach them to get additional information. But if whether it's a accommodation request for a vaccine mandate or some sort of an accommodation request of masking or testing, you want to make a quick decision. So that means you want to endeavor to either hire additional staff or train up your existing staff to be able to handle these matters quickly and swiftly. You want to document your decision. So if you deny the request, you want to make sure that that's documented. If you grant the request, you want to document that as well and maintain those records. And be sure when you're granting requests that you reserve the right to change your decision based on circumstances on the ground, right? So if the next variant is highly more transmissible or deadly, you may be pulling back accommodations or altering accommodations because of an undue hardship analysis. You may just say it's like a direct threat to the workplace at this point. So you want to reserve the right to change course. So a lot of these principles you're probably well familiar with. It's basically principles that are long established that you just kind of dump on the new requirements that the government is throwing at you. And you want to, evaluate them individually, make quick decisions, make consistent decisions, document it, and move on to the next one. So that's kind of the easy part of my presentation. The harder part goes to, the conflict that's developing in the states with these rules, almost from, some of these cases were filed before the mandate was even published. As soon as it was put on the website, the states started suing. So I'm just kind of got to give you a lay of the land on what the biggest conflicts between state laws and local laws are with the employer vaccination mandate under the OSHA ETS, and then talk about the state of the litigation and what it all means for you. I'm going to blow through it pretty quickly, so hopefully we can leave some time for questions. But the biggest one is states that have passed laws such as Texas that says that no employer can enforce a COVID vaccine mandate on their employees. I'm expecting, states such as Louisiana, Florida, Georgia, Alabama, Mississippi, and Oklahoma to jump on the bandwagon pretty soon. So what's clear is that if the ETS is deemed a lawful exercise of the federal government's authority, it's going to preempt all of those state laws. Under the Supremacy Clause in the US Constitution, the OSHA rules are going to preempt conflicting state and local laws, meaning that states can't pass laws that conflict with validly authorized federal laws. And that's just a function of the Supremacy Clause. So the big fight is whether or not the ETS is actually a lawful exercise of the federal government's authority. But for now, you're in a gray zone in states in which there are laws that prohibit you from enforcing this stuff because, the requirements in the ETS don't go into effect yet. There's currently a stay on the implementation of the ETS. So I think the best advice I can give in states, if you're operating in states where there is that conflict, is to comply with the state ban until such time as the ETS law goes, live. If it goes live without an injunction, then you want to default to following the federal law. I think that compliance with the federal law, if ultimately it's deemed to be unlawful at the end of the day, you're going to have some protections in complying with what was then a mandate that was in effect. While we're in this twilight zone where the ETS is not fully effective, follow your state laws that are banning mandates. And once the ETS goes live, I would, comply with the ETS. As Julie mentioned, that there's 20-something states that have their own OSHA programs that OSHA approves of, and so there's a timeline where those states such as Maryland and Virginia have their own OSHA plans where they can choose to adopt a policy that's in line with the ETS standard. They got 30 days to really decide what they're going to do. And OSHA is basically telling those states that if whatever you do, it has to be as protective as our ETS standard. But what I'm envisioning happening is in a lot of the red states, they're going to pass OSHA programs that thumb their nose at the federal government and basically go their own way. The federal government's not going to accept those plans, and that would probably lead to more litigation, further muddying the water in those states if that comes to pass. So it's just another area where we're going to continue to see conflict, and it's just something to monitor as this all plays out. So what's the current state of the litigation landscape over this? Multiple states have challenged the ETS already. I think there's pending litigation. There's in the Fifth Circuit. So these cases are being filed since they're challenging an administrative regulation. They're going right to the states are going right to the Circuit Court of Appeals. And that's the appellate court in the federal system. And there's lawsuits filed in the Fifth Circuit you know, in the Sixth Circuit, the Seventh Circuit, the Eighth Circuit, and basically what happens when there's a multitude of lawsuits filed in various circuit courts of appeals throughout the country is the federal system has a rule and a procedure that all of those cases are going to be consolidated based on a lottery, and they're going to go to one circuit. And that one circuit is then going to control the litigation over these challenges. And that's why you see kind of a race to the courthouse, because one of the, you know, you see a race to the courthouse in various circuits. So a lot of the conservative states are filing in what are deemed conservative circuits. And some unions have filed in states where the circuits are considered liberal leaning. And the hope is that that gets all these circuits in the mix for the lottery. And they're trying to influence where these cases are going to be all consolidated. But in the interim, we've already had a stay issued by the Fifth Circuit. So within a day of the lawsuit being filed, the Fifth Circuit Court of Appeals issued an order staying the ETS and was very short and to the point. It basically said that the petition by the states give cause to believe there are grave statutory and constitutional issues with the mandate. And so this panel of 3 judges instituted a stay and ordered the federal government to respond on November 8th. And the federal government responded. And basically, the federal government said, you know, a stay is premature. The mandates and positions are months away, they characterized it. And, you know, the burden of complying for the government is immense, because the government in their OSHA ETS calculates that thousands of lives will be lost if this ETS does not go into effect. And so basically they're saying, don't issue a stay. The burden of staying this enforcement are thousands of lives and hundreds and thousands of hospitalizations. And so don't stay this order. But the stay currently is in effect. And you know, any day now we may get a more thorough analysis or a more thorough order from the Fifth Circuit. But what's going to happen is once all these cases are consolidated, the consolidated court is going to decide whether or not a stay should continue. If there is a stay in place, the consolidated court will decide whether it continues. But while there's a stay, the ETS can't go into effect. And so what I think it's important for employers to do now is decide whether you're going to comply with this, regardless of whether ETS is deemed lawful or not. So if you make a decision, you throw up your hands and say, you know, we give in, you know, we're getting hit every number of ways from state, local, and federal governments to do this. We're just going to do it regardless, because federal law has been interpreted to say that employers can institute vaccine mandates, testing requirements, mask mandates. You employers can decide to do that. As long as you allow for religious and medical accommodation requests. So you can follow the litigation, you can follow the ETS and basically say, look, we're not going to institute any of this until this stuff becomes effective, in which case you as an employer want to align yourself with resources to help you monitor this stuff pretty closely, because it could, you know, it's, as you can see, it's all moving very fast, and the stays could be lifted, or, you know, and these things could go into effect. So if you're going to take a wait and see approach, I would advise to kind of get your ducks in a row, have your team together that can help you navigate and get in compliance pretty quickly if these stays are lifted and everything goes into effect. If you're going to be of the mindset of we're going to do this regardless because it's just time, you know, you're not having sunk costs at the end of the day if the ETS is struck down, or if it's, you know, never goes into effect, because you have made your policy decision that you're just going to institute something similar to the ETS for your own workforce. So organizationally, I think you make that policy decision now, regardless of how the litigation plays out. You know, if you can think back over the last decade, these contentious issues have taken years to play out. Some things in the Obama administration, the salary basis threshold change, never was resolved until he left office. Similarly, under the Trump administration, many regulations that were challenged never went into effect until he left office. So we could get, we may not have answers on a lot of this stuff for a long time. So I would make your policy decision now. Are we going to do this? Or are we going to say, no, we're not going to do this unless the government forces us to do that? And if once you make that policy decision, you can move forward and implement policies and procedures to comply one way or the other. And so we're monitoring it. We're going to continue to write on it and try to keep you abreast through the Lerch Early blog and otherwise through our listservs of developments. The news is certainly covering it. So there's not a dearth of information on it. So just keep your eyes and ears open for developments on the litigation front. But currently there's a stay in place, and we will see in short order how long lasting that will be. With that, we don't have a lot of time left, so I'll just kind of turn it back over to Scott to parcel out any questions that have come through.
All right, great. Thanks, Mike. Thanks, everybody. We have a bunch of questions. We don't want to go too far over. We want to be respectful of your time. So we'll try to take the next 7-8 minutes to get through as many as possible. And if you still have follow-ups, I'll be following up with an email with everybody's contact information. I encourage you to reach out to our attorneys, to Julie, Mike, and Nicole, if you do have any follow-up questions. So I'm going to try to get through these as quickly as possible. First, Julie, with your section, there's a couple questions about would the rapid test be an acceptable test option? I believe if it's approved and somebody else administers it, the answer is yes, but I'll let you address that.
Right. So yes, the test, as long as if it's the rapid test and it's not being both self-administered and self-read, and it's being used in accordance with the instructions, and it's an approved or authorized test according to the FDA, then yes, it is sufficient.
And then would the testing begin on 12/5 or 1/5?
So the testing begins at the same time that the vaccine mandate goes into effect. So the kind of the December requirements all have to do with the record keeping, the documentation, all of that stuff that has to happen kind of as a preamble, so to speak, for implementation of the action steps, the vaccination and the testing.
Gotcha. All right. This was farther back, but what if someone doesn't have enough paid sick leave to recover but needs the time off?
So if an employee needs to recover from COVID-19 side effects and they don't have any paid sick leave, you have to provide them with paid sick leave at their regular rate of pay for a reasonable amount of time.
Mike, you just hit on this one, but does the stay impact the timing requirement for the state plans? If you want to kind of reiterate what you just talked about.
Sure. So the stay is preventing the ETS from becoming effective right now. We'll think in the next week to 10 days, we should get some clarity whether, how long that stay is going to be in effect. A stay can last at the infancy, at the early stages of litigation while the court gets, more information from the litigants, in this case, the federal government and the states that are challenging it, or it can last all the way until trial. So the court could say, until we have a trial on whether this ETS is lawful, this regulation is stayed. But currently it's stayed, so it's not can't go forward. But we'll get more clarity before the timelines and the effective dates in the ETS.
Gotcha. And then this is somewhat related. As a Maryland employer, is the expectation that moving forward with all aspects of the ETS, even though MOSH has not issued a mandate, is the correct process to stay ahead of the requirements?
Yeah, I mean, I think we're a big believer in trying to stay ahead of the requirements, trying to be ready no matter which way you go. But that kind of goes to the point I tried to make in terms of making the policy decision. If you're of the mindset that we're not doing this until forced to by the federal government, then I think it still makes sense to try to get things in order. So if it becomes effective, you're ready to roll, because they're not going to then give you a grace period and say, oh, well, you guys didn't want to, you were waiting around. We get it, but they're not going to give you a grace period to then get in compliance. So the more work you can do now to kind of get your ducks in a row, the better, even if you're not going to go live on it unless and until it becomes effective.
And if you are looking at a state plan, the state plans have to be more protective than the ETS anyway. So you're not going to go wrong getting ready in accordance with the federal plan.
All right, these next three are all related to vaccines. First one is, even though we will mandate vaccinations, employees can still refuse to get vaccinated, and then they are required to get tested weekly, correct?
Well, I think that's going to depend on how you word your policy. So if you're mandating vaccination, which you are within your right to do, assuming you're not in a state that says you can't, then the testing isn't an option. It's only going to be something that you're going to provide as an accommodation, for a religious or sincerely held religious belief or medical condition. If you are going completely in accordance with the ETS, you're going to provide the testing option. So it's an or, right? You're either going to get vaccinated or you're going to do a weekly test and submit the test results every 7 days. So if you want to go in accordance with that, then yes, that is correct. It's the test or get vaccinated.
And so then relatedly, if the employee does not want to get vaccinated, but also does not request an exemption, that pushes them to the testing?
If that is how you framed your policy. The OSHA is making it very clear that employers, don't have to do the testing option if they don't want to.
Gotcha. And this was back from the section, but how do you know if it's work related when it comes to reporting the positive test?
So OSHA has said, when it's work related, when the work environment has caused or contributed to the resulting condition, which is not very helpful. And the OSHA, like I said before, published an FAQ, which acknowledges that it's difficult to make this determination. So it's going to be really based off the facts and circumstances of what happened.
Gotcha. All right, two more, Nicole, will stay with you here. To clarify, the employer has to pay a reasonable time for the employee to recover from having COVID or to recover from the vaccination, or is it an and?
The ETS only requires employers to pay reasonable time to recover from the side effects of receiving a COVID-19 vaccination, but there could be other requirements under other laws to have to provide pay time or just time generally for an employee to recover from having COVID-19.
Gotcha. This other one, I'll leave it up, but to whomever wants to respond, but what about the difference between work site and state of incorporation centralized management, and what rules apply? I'm not sure
that I'm following what that.
So the question was worded, what about the difference between work site and in the parentheses state one and state of incorporation / centralized management, which rules apply? And this was asked a while back. So
generally, under most employment laws are based on where the employee works, right? So if you have somebody that's working on a state that, let's say, is requiring additional paid leave associated with vaccination or something like that, and you have the employee working there, whatever significant amount of time is required by that law, then that state law will apply. It's an interesting question with regard to the state plan versus the, compliance with the ETS. But again, at the federal level, again, a lot of moving parts, and maybe we shall see once these state plans come out, we see what they look like and see what what happens with regard to the stay. That's about as best of an answer as I can give at this point.
okay, and here's the final one, and then we'll wrap up. If an employee refuses to provide proof of vaccination or refuses to get vaccinated, wear a mask, or get tested, does the employer have the right to terminate employment?
The employer does have the right to terminate employment.
Great. All right, Julie, if you want to wrap us up, that finishes the Q&A.
Yeah, thanks so much to everyone for all the great questions. We will, as Scott has mentioned, be distributing the recording of our presentation and the slides, and that will have all of our contact information. So feel free to reach out to any one of us with questions that you have on this, and we will strive to keep you abreast of all the changes that are happening as we see this unfold in the courts. Thanks again and have a great day, everyone.
Thank you.